Thank you. I think logically the next person would be John Turry, Public Defender, Rensselaer County.
Thank you. Could I just address one thing that's come up several times already? There seems to be this general belief that we need a commission on judicial conduct for judges because there are some judges who aren't lawyers, so they wouldn't be caught by the Committee on Professional Standards. By definition, in 499B2, a prosecutor includes any individual employed by or subject to the direction and supervision of a district attorney. That would be people who are not lawyers.
Well, I understand, and I
So
know. Okay.
there is a need for a separate commission. I just want to clarify that particular definitional issue that seems to have arisen several times already this morning.
Well,
Isn't it also true that the number is minuscule of the number of folks who are judges that are not lawyers?
Well, I don't think it's minuscule, but that wasn't the basis for framing.
I mean, I don't know that's
There are a
true or
large
not.
number
I'm
of
asking
judges
the
who are not
question.
lawyers, actually. But there are a large number of individuals who work in prosecutors' offices
Okay.
who are also not lawyers.
Coming from the city, I may not know better. I
Right.
just asked the question because I wanted to know.
Well, in the real world, upstate, we do have judges in town courts, but that was not the basis for the formation of the Judicial Conduct Commission.
Absolutely not, but I just want to
Okay.
make clear that in the
Okay.
definitional sections of this legislation that's being
Gotcha.
proposed, it's clear that if that's one of the reasons why people think we don't need to have a separate commission, it's not true, because quite frankly, the number of non-attorneys who are staff members of prosecutors' offices probably outnumber the attorneys.
Okay. Okay, go ahead.
As you said, my name's John Turry. I appreciate the opportunity, Senator, to speak this morning, to give you some idea of my perspective. My office defends thousands of individuals in criminal cases every year. I've been a defense attorney for over 25 years. I've also been a special prosecutor. I had the pleasure of working for the Commission on Judicial Conduct under Steve Downs when he was the chief attorney of the Albany office. I've appeared in commission proceedings as a witness for the commission. I've appeared in commission proceedings as a witness for a judge. I've also appeared in commission proceedings as the attorney for a judge. I'm a member of the board of directors for NYJTJA, as well as the Chief Defenders Association. And in that regard, last week the call went out to all the chief defenders around the state seeking individuals who might consider speaking here today. I won't bore you with the entire dialogue that took place, but I'll give you a little bit of it. It went something like this. Senator DeFrancisco is holding a hearing on the bill that would create an oversight agency for prosecutor conduct. Is anyone able, interested, willing to prepare testimony or to go to Albany to present? First response. I have stories, but I'm worried about retaliation if I were to speak publicly about the incidents. I won't suffer, but my clients would for sure. Will they hide me behind a screen and alter my voice? This is from one of the largest institutional providers of indigent legal services in the state of New York. Second response, I feel the same way. We have a lot of problems here, some making the paper lately, but I would feel uncomfortable testifying. Third response, I'd be happy to help write something, but I have the same concerns when it comes to actually testifying. You should be able to discern a common theme. The bottom line is this: district attorneys and judges hold unique positions of power. The manner in which they wield that power profoundly affects the lives of individuals, whole communities. As any practicing attorney knows, an angry or vindictive judge or district attorney can make you or your client suffer. It doesn't matter if you're a sole practitioner, a member of a law firm, or an institutional provider of indigent legal services. This is a given in the everyday practice of law. Attorneys who practice in a community live in that community, and they have to make a living in that community. And they're painfully aware of the price they pay if they lodge a complaint alleging misconduct. Retaliation can take many forms. Attorneys are fearful to report prosecutorial misconduct. The prevailing mindset is that prosecutors are untouchable, even when their conduct is most reprehensible. Their worst outcome might be the preclusion of evidence or maybe the dismissal of a case. Prosecutorial conduct is rarely reported to the Committee on Professional Standards. I personally believe a commission on prosecutorial conduct would enhance the likelihood that improper conduct would not only be reported, but it would be addressed in a fair and efficient manner. The ability to report misconduct in confidence, coupled with a commission's ability to initiate investigations based on its own complaints, in my opinion, are critical elements to an efficient and effective system. The Commission on Judicial Conduct has proven itself year after year to be an efficient, fair, and reasonable mechanism to address alleged misconduct of judges, and it's an excellent model for a commission on prosecutorial conduct. There was a letter that I read from the District Attorneys Association. It was written in June of 2015 to the Honorable John Flanagan, and it was addressing the creation of the Commission on Prosecutorial Conduct, or as they said, misconduct. I just want to briefly address a few points in the letter. First and foremost, willful prosecutorial misconduct is actually extremely common in New York State. Apparently, the District Attorneys Association is only concerned with prosecutorial misconduct that results in wrongful convictions of innocent people in major crimes. In other words, cases that make news, cases that are big, cases that are obvious. Willful prosecutorial misconduct is wrong, and it must be addressed regardless of whether the prosecutor believes the individual is innocent or guilty, regardless of whether the charge is a violation, a misdemeanor, or a felony, and regardless of whether the end result is a conviction or not. Prosecutorial misconduct has direct and collateral consequences in individuals' lives. People's lives are put on hold, they lose their ability, whether it's to have public housing, income, job, and quite frankly, just plain simply their liberty. The claim by the District Attorneys Association that indigent defendants can pursue claims of prosecutorial misconduct in the state courts by motion or by filing appeals, presumably after they've been improperly convicted and incarcerated, is downright appalling. Why should a defendant have to be convicted as a result of prosecutorial misconduct when that misconduct should not have been allowed to occur in the first instance? If a commission on prosecutorial misconduct existed, perhaps the prosecutor might not be so inclined to commit the misconduct if he or she knew that actual consequences would follow. The District Attorneys Association also claims that the creation of this proposed commission would cause public safety and the fair administration of justice to suffer. Quite frankly, these claims are nothing more than a lame attempt to inflame the public and to suggest that the creation of this commission will somehow create mayhem in the streets and in the courts of the state of New York. I'm confident that the members of the Assembly and the public they represent can see through this thin layer of smoke. The District Attorneys Association, and you've heard it referred to here again today, they refer to a myriad of effective review and disciplinary mechanisms already in place as a reason not to create a commission on prosecutorial misconduct. In reality, those mechanisms are twofold. First, the prosecutors are watching themselves, bringing to mind the old adage of the fox guarding the henhouse. And second, the 4 grievance committees. They generally oversee attorney misconduct. Without a doubt, our grievance committees do good work, and they generally address attorney misconduct. But that does not mean that there's not a need or room for a separate and distinct commission whose sole purpose is to oversee the professional conduct of prosecutors. Prosecutors have extraordinary power, and they should be subject to greater scrutiny. Such a commission, staffed with individuals who are well-versed in criminal law and procedure, would fill a vacuum in the criminal justice system and provide a uniform system of standards and procedures and enforcement. As it relates to self-regulation, one only needs to read the headlines to gauge the effectiveness of self-regulation by district attorneys. Headlines such as, FBI probes district attorney's office, or judge accuses district attorney of misconduct, or Schneiderman sues DA, might be an indication that self-regulation is not working. And I thank you for your time.
Thank you. Although you didn't ask to testify, you apparently are very anxious to say something.
Tom Zugaby asked me to step in his stead.
Okay, I didn't realize that. You'll be next, but let me call, in order to balance this, Jeff Deskovic.
Deskovic, yes.
Could you go on?
Yeah, thank you. My name's Jeffrey Deskovic. I'm the founder and executive director of the Jeffrey Deskovic Foundation for Justice, which works to free wrongfully convicted people as well as prevent wrongful convictions. I'm also an advisory board member of It Can Happen to You. I have a master's degree from John Jay College, so my views are not going to be shaped solely by my own personal experience, but also by my formal as well as informal study. I started my organization as a first-person advocate because I served 16 years in prison in New York. I was wrongfully convicted of a murder and rape, which I did not commit, despite a negative DNA test. The results of this wrongful conviction was that I was in prison from age 17 to 32. Prosecutorial misconduct was a major factor in my wrongful conviction and preservation of same. Firstly, the trial prosecutor, when the DNA test did not match me because I was excluded pre-trial from results from the FBI lab, one day before officially receiving those results from the lab from the FBI, he rushed off to the grand jury to obtain the indictment so as not to be able to have to present that evidence. In the furtherance of going against the exculpatory DNA test, which should have resulted in the case against me ending right then and there, the prosecutors suborned perjury on the part of the medical examiner, getting the medical examiner to fabricate findings of an autopsy, findings which he had not mentioned when he initially did the autopsy. It took him 6 months to come up with these findings in order to help the prosecutor get around the DNA test result. It enabled the prosecutor basically to argue that the victim, who had already lost her life and had been raped, he trashed her reputation and insinuated that she had been sleeping around, and so therefore it didn't matter that the DNA did not match me because it could have come from one of these consensual sexual episodes. Not only did he argue that against me, but then he named another youth by name that he falsely claimed that had this encounter with the victim, but he made an improper argument in doing that. He never presented a proper evidentiary standard. He didn't have a DNA test result performed on this other youth. He didn't even call him as a witness. He just made the unsupported argument to the jury. When the hair on the body did not match me, again, the prosecutor resorted to an improper argument that he made without first establishing an evidentiary foundation. He claimed that the hairs must have come from the medical examiner and his assistant. I later learned during the discovery process of successful litigation that I brought once I was exonerated, that when the hair expert learned that that was the argument that the prosecutor was going to make, he requested that the prosecutor provide him with the samples, and that prosecutor declined to do so. That was also never turned over to the defense. I want to add that my civil rights lawyers were able to find 3 additional cases in which the same trial prosecutor, George Boland, had worked with this medical examiner, altering results in order to fit prosecution theory. In addition to that, I also, there was prosecutorial, well, let me just add that nothing ever happened to that prosecutor. When I brought successful litigation, although all the parties ultimately settled with me except for the one party that I went to trial with and won a jury verdict on, the case against the prosecutor was dismissed based on prosecutorial immunity. In his footnote, the judge dismissing it said he felt constrained by the law to do so, but that he wasn't dismissing it because he didn't find that I had evidence or that the allegations were not serious. He noted that I could pursue a remedy outside of the courtroom. So when everything finished, I circled back with my civil rights lawyers and I told them that I wanted to file a complaint. I wanted to take the judge up on what he had suggested. And my civil rights lawyers, who had done a spectacular job for me, told me that it would be a waste of time and it would be a waste of money because nothing ever happens. So basically, the prosecutor got away with it. I want to add that 2 weeks before I emerged, suddenly he retired and ran to Florida. I guess we're supposed to believe that's a coincidence. So although he's not practicing law now, he still retains a law license and he could practice law at any point in time in the future. More importantly, nothing ever happened to him, certainly not criminally, not in the courtroom, not civilly, no censure, nothing. I was a victim of prosecutorial misconduct on the post-conviction level. First of all, I had requested further DNA testing twice from then Westchester District Attorney Jeanine Pirro, she rejected my efforts at getting further DNA testing, even though there was a prior Westchester County case, that of Terry Chalmers, in which she consented to exoneration based upon exculpatory DNA test results, stating publicly and defending that exoneration that the DNA test results made it clear that it was the right thing to do. So she knew, her and her office were well aware of DNA implications and its power, and yet she saw fit to deny me twice the testing. On the federal level, her office successfully got the court to dismiss my habeas corpus petition because I was 4 days late. The court clerk gave my lawyer the wrong information regarding filing procedure, and I had an actual innocence argument there based on the pretrial DNA, and they made that argument. Attorneys in that district attorney's office made arguments as spacious as saying that there was overwhelming evidence of guilt, which was laughable if it wasn't such a serious thing, considering the DNA. Mrs. Pirro there's nothing to stop her from practicing law. Nothing ever happened to her. My organization.
She's a judge now, isn't she?
She's a judge now, yes.
A fake judge on TV.
A TV judge, yes, but we all, yeah, of course, but we understand what I'm trying to get at, though.
I got you.
In the case of two of the clients at my foundation that we were able to exonerate, Mr. William Lopez, who served 23 and a half years in prison, the federal judge in releasing him stated in his opinion that he referred to there being a deceitful prosecutor. I want to share the tragic news in terms of to bring home the human impact. My friend, my client, he died after a year and a half of freedom. His life basically stolen from him in large part based on prosecutorial misconduct. The other exoneration, that of Mr. William Hawley, which was up by Putnam County DA Tendy's consent, which I want to give him credit for doing. The prior DA, Putnam County DA Levy, offered 3 different times to release Mr. Hawley, but on condition he would have to plead guilty. Just the fact of him making that offer after a conviction had already occurred in an arson case that wasn't actually an arson showed that he knew there was something wrong with that conviction, and yet he insisted on that despicable condition, which Mr. Hawley refused to cave into, and ultimately he was exonerated. There's a lot of studies from the Innocence Project to the California Innocence Project to the Pew Center to remarks by federal Judge Kozinski, to studies from various newspapers and magazines of stellar credibility, that there's a prevalence of prosecutorial misconduct. If the present system was enough, then there would not be a prevalence of prosecutorial misconduct. In all these different wrongful conviction cases, the common denominator is often prosecutorial misconduct. How many prosecutors in the studies that have been done of those cases have been disciplined afterwards? I want to also add that each one of these instances has cost New York State millions of dollars, but more importantly, it devastates the lives of the people affected. My family and the family of many of all the wrongfully convicted people, they were impacted as well, and there was a larger societal cost. The actual perpetrator in many of these cases strikes again. It happened in my case. The actual perpetrator killed the second victim 3.5 years later. There is no deterrent. I don't think that training, I'll wrap up in just a second. I don't think that training and, referencing various methods of reversing a wrongful conviction, that's not discipline. While certainly a big part of this, as I see it, my being a supporter of this, is a deterrent, some of it has to be punitive as well. When intentional, clear-cut misconduct happens, training doesn't quite cut it. I don't think you should consider you should consider exonerees to be survivors of crimes that were perpetrated against us. And I can't think of any other penal offense where an offender receiving training would be considered to constitute justice. And my last remark would be, and I thank you for having this hearing and entertaining myself and the other panelists, is while there has been a couple of good changes, I mean, the Putnam DA did do the exoneration, and the Bronx DA sitting to my right did have the Richard Rosario case overturned, which I give her a lot of credit for, 13 alibi witnesses. And I want to point out that the indictment is still not dismissed, by the way, even though there's the 13 alibi witnesses. But going past that, while we do have a couple of great changes in the promise of justice within both of those offices, we cannot say that that means that there's a prevalence, that that's the general attitude, that's pervasive. That's not, you can't overgeneralize that. And I think the biggest reason why you should enact this legislation and have a commission is that there is a denial within the profession of prosecutors that prosecutorial misconduct, that it happens. And so long as there's a denial, that's even more reason to note that it's not going to end if we keep the status quo as it is. Thank you very much.
Thank you. We have two more speakers. First of all, Robert Masters, the Assistant District Attorney of Queens County, and then we're going to have Emily. We left you last because you're going to be the star of this proceeding. I apologize, but somebody had to be last.
To start proceeding?
Go ahead. Star up.
Thank you for hearing me on such short notice. Tom Zugaby last night asked me to substitute for him.
Okay.
Really, the only one that I'm at all acquainted with among you is really you, Senator DeFrancisco. It seems over the last decade or so annually, this week in June, I come to talk to you, if not about this or about something else that's important in the criminal justice arena. And I have to say that although we may disagree about this particular topic, I've always found you to be a very fair and thoughtful voice in all of this area.
Continue, go ahead.
As I've been listening, I'm mindful of something that John Adams said, not well before he was president, and actually before there was even a United States. It was when he was defending those British soldiers in the Boston Massacre. And during his summation, he said repeatedly, facts are very stubborn things. And I think that while what we've heard here today is incredibly important, and we all have to continue to focus on this to try and make for better prosecutions and for a better criminal justice system, I think certain facts have to be looked at and have to be accepted. Only last year, the Office of Court Administration finished its commission's review of the attorney discipline in a report that was published in September. And in the report itself, it specifically concluded that there was no evidence of rampant prosecutorial misconduct. I think what we're working here, and I know that Judge Clark alluded to it, as did Scott McNamara earlier, I think we're in a difficulty of looking at definitions and labels. And prosecutorial misconduct is a very broad umbrella that covers an awful lot of sins. It does cover intentional, moral, awful misdeeds on the part of someone. But it also covers summation error, a mistake in cross-examination, and when the accusation is briefed, that's the label that's applied to it. When a case is reversed, that is the label that is applied to it, regardless of whether it was a mistake or something intentional and awful. The District Attorneys Association has taken this very seriously over the last few years. And Jed Painter from the Nassau County DA's office was the one who really led a remarkable review of all of the reported decisions in New York State between 2010 and 2015. And he had a committee of people reviewing all of these cases, and pretty much he looked for every iteration of any discussion of the term prosecutorial misconduct. And although it was raised in that over 5-year period, in 556 cases. What it turned out was that ultimately the courts only addressed it, only found it substantiated, and that didn't mean reversal, but substantiated in 54 cases total over a 5-year period across the state. And I have to tell you, that winds up being less than 10% of the times it's alleged. Among those 54 cases, almost 30 of them were summation error or errors in cross-examination of defendants. In our office, before myself and the Chief Assistant Jack Ryan testified before the Justice Task Force in January, we did an examination of the last 3.5 years of all of the reversals in the Second Department in our office. And what we found was that there were 10 times more reversals for judicial error than there were for prosecutorial misconduct, that just in particular topics that the reversals were on. For errors in conducting and handling by the court of jury notes, we had twice as many on just that topic alone reversals than we did of prosecutorial misconduct. And yesterday a decision came down from the Court of Appeals that would undermine all of those reversals. So that tells you the idea of how fluid the law is and how minor this topic is. There were as many reversals out of Queens County, which I know it's just one of the 62 counties in this state, but it is a county with a population that's larger than 13 states in the United States. There were as many convictions, there were as many reversals for ineffective assistance of counsel as there were for prosecutorial misconduct. And every one of the pros-mis reversals in my office was summation error. And that's one of the things that I think you should also realize. Summation error as a basis for reversal, which of course is the basis for applying that label of prosecutorial misconduct, is a very variable thing. It's strike zone dependent. And I think what we all know, for instance, in the recent trials of members who were formerly of this body, that things were said in summation that were reported in the news in those trials that I don't think there's a lawyer that practices in the state system realizes would have ever passed state muster. So those are things that I think that everyone should realize, that we, in New York State, we have one of the most, I think, diligent standards that's applied by the courts of reviewing when prosecutors are summing up. When I did appear in front of the Justice Task Force in January, I quoted from a summation in the famous Fatal Vision case where Dr. Jeffrey McDonald was convicted of the murder of his wife and 2 children. I'll spare you the portions and the riffs of that summation, but that case was reviewed by the Supreme Court of the United States twice. And when I read the portions of it, Judge Carmen Saparik, who was one of the chairs of that commission, came over to me afterwards and said, "You made that up, didn't you? That can't be so." I sent it to her. Nothing like that could ever transpire in the state of New York. We are very much restricted in that area. But that doesn't mean that we don't try and fix it. In an hour and a half from now, this is Wednesday, the Second Department will have its hand-down list. And one of my jobs is to examine what the Second Department says about our work. Last Wednesday, January 1st, was Judge Brown's 25th anniversary as the DA. We had a little celebration for him. Went back to my office afterwards and saw the hand-downs. There were 2 cases in which assistants were cited for prosecutorial misconduct, both for summation error. At 8 o'clock the next morning, Judge Brown called me to basically ask me, "We have to meet about this. I want to know what's in those summations. I want to know what's in those briefs." The reason I'm not in the meeting with him this morning is because I had to cancel it to come here today. We will go over those summations line by line with the district attorney of a county of 2.4 million people. The assistants will either be disciplined, they'll be corrected, they may even be sent back for retraining. Something will happen. We will make sure that that doesn't go on. And just a few other points that I think are of some significance. Mr. Deskovich was kind enough, I believe it was in late 2009 or 2010, I don't know if you remember me. He was kind enough to come to the Best Practices Committee of the DA's Association. here in Manhattan, in Manhattan. He spent hours with us, and I remember I questioned you about a number of real specifics about how his case evolved. And after he left, we spent the next 2 hours, a group of all the senior prosecutors in the state, discussing a number of things about how the misfortune that befell this man, how it occurred, where the system didn't work. We spent several meetings after that, once again discussing how did that happen? How did that occur? What can we do to stop it? By December of 2010, that's when the district attorney's office presented its guidelines on videotaping statements and interrogations. And all of the things that this man was subjected to have been sworn off against and are no longer the protocols and are against all the protocols that have been adopted by every police department in the state. Now, one thing that I will just say is we've talked about a case that occurred in my county. And it was a young man, he's not a young man, my contemporary, Claude Stewart. And Claude Stewart was a remarkable man who, frankly, was a terrible lawyer. He was a native of Belize. He immigrated here, joined the military, served in the Gulf, went to law school, and I have to say that we truly, he was a brave man, a wonderful parent, a good husband, and I have to say that our office fell in love with his story. And I think we overlooked again and again the fact that he was not a particularly good lawyer. And we advanced his career to handling cases that he was not capable of handling. And what we saw with Claude was what I think I have seen as a supervisor over the years. Most misconduct, and where assistants do things that are ethically dubious, it's not the really good ones. It's not the smart ones. It's not the talented ones. It's the ones who are struggling. And the ones who are struggling generally don't have the skills to deal with the evidentiary difficulties, to handle a particular case. And those are the ones that stop asking for advice because they're afraid when they ask questions, it reveals their lack of skills. It reveals their inability to handle themselves, and it may affect their careers. And I think that our office clearly learned in the wake of what happened with Claude that those are the assistants that we make sure get the most training. Those are the ones that we make sure wind up with the portfolios that are much less significant, where they're in a situation where they receive more guidance and can do the least damage and ultimately can be counseled through their career. That's something that we learned. So I hope that I've informed you of some of the things and the parameters that goes on in the day-to-day operation of the criminal justice system as far as we see it. I think that the discussion, Senator, that you've been bringing to the fore for, I guess it's 4 or 5 years now that I've been coming up here with it, although we continue to disagree about the end result, I think you should realize that it has been remarkably productive in that I don't know that 5 years ago the letter that Mr. Zugaby sent to the 3rd Department Character and Fitness Committee with regard to Ms. Rain would have ever happened. And I don't think that a number of the policing that we're doing among each other and watching each other and asking for the advice and trying to make sure that our house is in order would have occurred without you applying the pressure that you have. But I think that all the faults that everyone else has applied, the unintended consequences that have been mentioned in the legislation, I think still make it a policy that is a policy issue that could present far more problems than it'll solve. Thank you, Senator.